Hello friends, we have been studying the 2-mark questions from Administrative Law. So far we have covered 20 questions in 2 previous videos. In this session, we will be discussing the final set of 10 questions. Welcome once again to Nyayacharya Learning, your companion in mastering law. Make your studies more effective by listening to our podcast and staying tuned for more insightful sessions. Let's begin with our first question. What is an institutional decision? An institutional decision in administrative law is one made by a department or administrative body as a whole, not by a single officer. It reflects collective action where authorship is depersonalized and the outcome is attributed to the institution itself. Such decisions integrate the expertise of many officers and ensure efficiency in complex governance. In local government, Board vs. Aldrich, a house closure order was upheld as the department's institutional decision, though based on an inspector's report. These decisions balance administrative complexity with principles of natural justice by allowing collective, functional and accountable processes. Now we move on to the next important short question. What is official bias? Official bias in administrative law arises when a decision maker is predisposed to uphold a policy or departmental objective, compromising impartiality. Unlike personal bias, it stems from vested interest in advancing institutional goals. It violates natural justice by creating a reasonable likelihood of unfairness. In Gullapalli Nageshwara Rao vs. APSRTC, the secretary who initiated a transport scheme also heard objections which the court held as biased. Guided by the principle Nemo Judex in Causa Sua, such bias invalidates administrative decisions. Here comes another key question you should never miss. Define delegated legislation. Delegated legislation refers to laws made by authorities other than the sovereign legislature under powers granted by a parent or enabling act. It allows the executive ministers or local bodies to frame rules, regulations, bylaws or notifications for effective governance. This delegation saves legislative time, ensures flexibility, and enables experts to handle complex details of modern administration. Though practically necessary, in a welfare state, delegated legislation is subject to judicial review to prevent misuse and maintain constitutional limits. Let's take up the following question and understand it briefly. What is substantive ultra vires? Substantive ultra vires in administrative law means an act or delegated legislation goes beyond the powers granted by the enabling statute or constitution, making it invalid. It occurs when an authority exceeds statutory limits, enacts rules not authorized by the parent act, or infringes constitutional provisions. Unlike procedural ultra vires, it concerns lack of substantive power itself. Now friends, listen carefully to this 2-mark question. 2 important functions of the Union Public Service Commission UPSC are conducting examination and recruitment. The UPSC conducts competitive examinations and interviews for appointment to the All India Services and Central Services, ensuring merit-based recruitment and maintaining an efficient administrative system. The second one, advisory role on recruitment and discipline. Under Article 320 of the Constitution, the UPSC advises the President on recruitment methods, promotions, appointments, and disciplinary matters concerning government servants, ensuring fairness and accountability in public service administration. We shall continue with the next short question in sequence. Define corporation. In administrative law, a corporation is a legal entity created by statute, recognized as an artificial person separate from its owners, capable of holding property, entering contracts, and being sued. It has perpetual succession, ensuring continuity despite changes in membership. Key features include a separate legal identity, limited liability for owners, public purposes like providing essential services, a common sale, and autonomous management. Corporations are established to carry out statutory functions efficiently, combining legal recognition with operational independence to serve public or governmental objectives. The upcoming question is a common one in exams. Difference between delay and laches. Let's make the comparison between delay and laches in a table format. Definition of delay: the lapse of time between when a right or claim arises and when it is asserted. Definition of laches: an equitable doctrine preventing a claim after an unreasonable delay that causes prejudice to the opposing party. Nature of delay: factual occurrence describing the passage of time. Nature of laches: legal or equitable principle based on the facts of delay and prejudice. Focus of delay: duration of time elapsed. Focus of laches: reasonableness of delay and its harmful effect. Consequences of delay may affect evidence, circumstances, or claim validity. Consequences of laches: bars the claim to ensure fairness and prevent injustice. Application of delay: not automatically legally binding. Application of laches: applied by courts when delay is both unreasonable and prejudicial. Here is another interesting question to sharpen your understanding. What is estoppel? In administrative law, estoppel prevents a government or administrative body from denying or contradicting a previous statement, promise, or action on which a citizen has reasonably relied to their detriment. It ensures fairness and accountability, avoiding injustice or misuse of authority. The key elements are a clear representation or promise, intention for it to be acted upon, reasonable reliance by the citizen, and resulting detriment. Promissory estoppel applies when a government promise induces reliance causing loss if withdrawn. The doctrine's purpose is to uphold justice by preventing the state from acting inconsistently or unfairly against those who trusted its assurances. Let's take the next question and see what the answer is. What is doctrine of procedural ultra vires? The doctrine of procedural ultra vires holds that an administrative action is invalid if it fails to follow the mandatory procedures laid down by the parent act or other laws. It ensures that authorities act within their powers and maintain the rule of law. This doctrine mainly applies to subordinate legislation such as rules or bylaws made under an enabling act. If mandatory, procedures like consultation or publication are not followed, the action becomes void, whereas failure to meet directory requirements may not. Its purpose is to provide checks and balances, protect individual rights, and uphold procedural fairness in governance. This next question will further strengthen your basics. What are the two postulates of rule of law? The doctrine of the rule of law rests on two main postulates. The first one, supremacy of law. It means that law is supreme and no one can be punished except for a breach of law established by legal authority. It rejects arbitrary power and ensures that government actions are governed by law, not by individual discretion. The second one, equality before the law. It ensures that all persons, including government officials, are subject to the same legal process. It prohibits special privileges or separate courts and guarantees every individual equal protection and fair access to justice under the same legal system. Finally, let's address the following 2-mark question together. Difference between red light theory and green light theory. The red light and green light theories represent two contrasting views in administrative law about the control of executive power. The red light theory stresses judicial control and legal limits on government action to protect individual rights and prevent abuse of power. It views executive authority with caution and insists on strict adherence to the rule of law, reflecting the laissez-faire belief in limited government. The green light theory, on the other hand, sees law as a tool to promote effective governance and collective welfare. It supports broader executive powers, emphasizing efficiency, policy implementation, and political accountability through mechanisms like parliamentary oversight. Dear friends, with this we conclude the complete set of 2-mark questions in administrative law. Thank you for learning with Nyayacharya. Stay tuned and keep growing in your legal journey. We'd love to hear from you. Share your thoughts and suggestions in the comments below. In our next video, we'll begin exploring the 2-mark questions from the past 5 years of Transfer of Property Act, an exciting and essential area of law for every student and practitioner. So don't miss it. Subscribe, stay connected, and keep the spirit of learning alive with Nyayacharya.